That's called the case of the people versus Stephen Johnston.
Good morning, Aaron. Alex Green on behalf of Mr. Johnston. I'm requesting permission to practice pursuant to MCR 8.120 under the supervision of Attorney Lauren Brown.
Really? Okay, permission to practice is good.
Stephen Michael Johnston, Your Honor. How are you?
Thank you.
This morning.
I'm just wonderful. Yourself?
I could be doing better, Your Honor.
Yeah, I know. Sometimes it'd be that way. Go ahead.
Your Honor, we're asking the court to set the matter for a preliminary examination.
All discovery is complete.
Yes, Your Honor.
People have the witnesses available on the 16th. Preliminary examination will be set April 16th in person, 9 a.m. before
Fresh hour.
Judge Fresh Hour.
People would like to be heard on bond. Good time.
Yes, go ahead.
2.1 is the amount of his bond and 2 are his phone calls. First, at the time that I charged this case, I requested a $50,000 cash surety bond. The magistrate set his bond in the amount of $40,000, 10%. I'm requesting,
40,000?
40,000, 10%. I
Okay,
don't know, yeah. But I'm requesting the 50,000 again. The defendant is charged with strangulation and domestic violence. There may be an additional charge of possession of meth coming as well. The suspected meth that the defendant had in his backpack upon arrest is currently at the lab. If we get those test results that come back meth, we'll be charging that also. But in this case, the defendant used one hand, put his hand around the victim's neck and strangled her. He then put his other hand into her face, covering her mouth and her nose. The lethality report that the police filled out reflected the victim was struggling to breathe while he was doing this. Prior to strangling her, he had hit her in the face with a plastic fan. And the police were able to observe injuries to her. She had redness to her neck and she then received medical treatment. The defendant also has 1, 2, 3, 4, 5 holds. 2 are from Trenton, 1 is from Lincoln Park, and 1 is from Dearborn. Those 4 are all traffic offenses. However, he does have a Dearborn Heights domestic violence hold with a $500 bond on that. I don't know the circumstances of that domestic violence case, but I'll be reaching out to them to get a copy of that report. So first, I'm requesting that the bond be increased to $50,000. Yesterday, I received notice from an intern that works in our office who had the opportunity to review all of Mr. Johnson's jail calls. And the intern sent me a memo about 8 of the defendant's jail calls. I immediately reached out to Mr. Warren Green. I downloaded the 8 jail calls and sent them to Mr. Warren Green. And I had the the Sheriff's Office Record Department yesterday send Mr. Warren Green all of the defendant's jail calls. So they've had access to them for almost as long as I have. In the 8 jail calls, the defendant placing calls to the victim despite a no contact order with the victim, they are discussing this case in detail. They've discussed the victim changing her story, that the victim is going to take responsibility, that she's going to say that she remembers things differently. The defendant directs her to call the prosecutor's office and, I quote, be on their ass a little bit, make them drop the charges, tell them that you want this dropped. As if Ms. Barroso was here, she would say that he then engages in love bombing, telling her how much he loves her, that he wants to marry her, that he wants to put a ring on his finger, that he just wants to get out of jail, tell the prosecutors to drop the charges. My office has been in contact with the victim to continue to offer her support. The officer in charge from Ann Arbor yesterday was also in contact with her to offer her support as well to allow us to move forward with these charges. My office is looking into whether or not we will be filing a forfeiture for wrongdoing against this defendant should this victim ultimately decide to tell us a different story. However, based on the supports we're providing her, I'm hoping that is not the case. And we're also looking into witness intimidation against the defendant. So A, please increase this bond to $50,000 as I initially requested, and B, will revoke his jail call privileges as well. Thank you.
response.
Thank you, Your Honor. As Ms. Hughes said, she did send those phone calls over to me yesterday. I had an opportunity to listen to those. I had an opportunity to speak to my client. Mr. Johnston understands that any contact with a complaining witness is a violation of his no contact order. He assures me he will not contact her whatsoever moving forward. Our only request is that the court retain the 10% privilege in his bond. If Mr. Johnston were to post, he would reside with his grandmother in Redford. He was employed fully before this as a sales rep at AT&T. Mr. Johnson has 2 children and only has 1 prior conviction on his record for a traffic.
Just to, and maybe I didn't understand what you said. He has a 2023 domestic violence conviction.
Your Honor,
And Your Honor, I apologize. If that's true, all I can see in his Michigan criminal history is 1 prior conviction for the traffic matter.
Your Honor, may I speak, please?
We have an attorney. If you want to, you can go ahead.
Your Honor, I was not aware that I wasn't allowed to contact my fiance.
Really?
No, I didn't. When the video during the court in the inside of the jail cell has been glitching.
And Your Honor,
Oh, it
Your
was
Honor,
a
he's
glitch when the
certainly-
magistrate was saying.
But I am aware now, Your Honor, I am aware now that I'm not allowed to contact her whatsoever. But I did not love bomb my fiance whatsoever. My fiance openly in the
Stop
state.
it. Stop it. Your Honor, I think what Mr. Johnson meant to say is there were no
Oh,
threats.
what he meant to say what?
He was absolutely not threatening any witnesses in the case.
No, I wasn't. Not
Was he
whatsoever.
telling her to change her story?
No, I was not. She openly, you can listen to the
Oh,
call.
you don't want me to do that.
Oh, but I'm telling you, the very first phone call with her openly admitted to it. I didn't coerce her.
Your Honor, we're asking to proceed to preliminary exam.
Yes, miss. There's more.
No,
Go ahead.
No, just to be completely candid with the court, I said it as a conviction. I'm sorry. In 2020, he was bound over in Wayne County on the domestic violence and child abuse charges. I said it was a conviction. It just says bound over in the judicial segment. I apologize. I need to be clear. I don't know what the ultimate outcome of that case was.
Your Honor, my understanding is that case is set for trial in May.
So he was out on bond in felony child abuse charges. And
When this occurred.
yes, thank you.
Anything else?
Nothing from the defense, Your Honor.
I would find that I'm not sure where the 40 comes from, but whatever. I find that the 10% is an abuse of discretion, given all of the circumstances. The defendant's the 10% privilege. I will not raise it to 50, but it'd be $40,000 cash surety will be his bond. Further, it was clear, and it was less than 10 days, well, less than a week. This defendant was arraigned, and all of this has occurred, and the phone calls have been listened to, and he shouldn't have been in any contact whatsoever with her. Just plain and simply shouldn't have been in any contact, regardless of the contact. Defendant's phone privileges are hereby revoked in their entirety. Thank you.
Thank you, Your Honor.
Thank you.
Case versus Deidre Woods. Excuse me.
Lori Gaines, Senior Assistant Public Defender, with and on behalf of Ms. Woods. Your Honor, at this time, we'd like to, Ms. Woods does want me to address her bond to see if she can get a personal recognizance bond. There was a request. We made a request to see if we could resolve this with misdemeanors. At this time, we are not able to do that, and there are no offers. Ms. Woods is indicating that she wishes to waive the preliminary exam now then instead. Is that correct?
Yes.
And be bound over to circuit court. I can have her sign a waiver and so that we can do that.
Woods, is that correct? You're waiving your right to have a preliminary examination?
Yes, Your Honor.
You understand that that's a proceeding where the people would have to show by probable cause that the offenses alleged were committed and that you committed them.
Yes.
You understand you'll not have that hearing and you'll proceed to circuit court for further resolution.
Yes.
People also waive their right.
Yes, Your Honor.
Preliminary examination having been waived, defendant is bound over to circuit court on 4 counts with count 5 following. Ms. Gaines.
May I address you with a statement, something positive that I've done since you.
I'm sorry.
May I address you with something positive since the last time I was in front of you, Your Honor?
I think she wants to address bond, so
Okay, go
in
ahead.
terms
I
of
was just
what you
gonna
did
say-
positive, in terms of, you're talking about turning yourself in on the warrant.
Yes,
Yes, so we'll talk about that when we get to the bond.
okay.
Okay, all right. I didn't forget. Okay,
All right, so you're waiving formal reading and standing mute.
that is correct, Your Honor.
Defendant having waived formal reading, standing mute, court will enter a not guilty plea. Pretrial will be set for
April 17th at 1:30 before Judge Conlon.
April 17, 2024, 1:30 before Judge Conlon. Bond, go ahead as the bond.
Your Honor, at this time, I'll start where, with what, Ms. Woods would like you to know. The last time, she says the last time she was before you, she did have an outstanding warrant from, Wayne County,
Yes.
where she had to go to the Mound facility, she stated. She says that that is all taken care of. At this time, she does have two other cases that are pending, but she has personal recognizance bonds in both of those. She has a permanent address in Ann Arbor that I believe was provided to the court at the arraignment. And she indicates that she can return to that address and she would return for all future court dates. She also did have a job. She's not sure, now that she's been in custody for a while, if she'll be able to return to that, but she would like to try to get that back. And your job was where again, ma'am?
That Helping Hands.
At Helping Hands.
Also, I have to report next week on the 10th in front of Judge Barr. So I was like for you to grant me a personal recognizance bond. I'm trying as hard as I can around there.
So that you have a bond on that case?
Yes, I'm on personal recognizance now for that case.
Yes, sir.
The one before Judge Barr?
Yes, sir.
All right.
That's correct. And the one, as I said, the one in front of Judge Valvo, I believe she has
It's
sentencing
at
today too
1:30.
for
Yes.
that. And there's a personal bond on that for her as well.
Okay. I'm proud of you, Ms. Gaines. That's the shortest bond argument you've ever given. Ms. Hughes.
Thank you, Your Honor. Your Honor, when my office charged this case, we requested 25,000 cash surety. I didn't do that request. When Ms. Woods' case initially came up on the docket, Mr. Ron Brown was assigned to this file. He called me for us to talk about this case, and I said, didn't we already handle her case? We just pled her to misdemeanors 2 weeks ago. Oh, no, that's because this is a brand new case. We were in front of Your Honor on March 14th, 2024, where she was charged with larceny and receiving concealed stolen property. Her and a co-defendant went into an apartment complex full of TV. I pled that down to misdemeanors in front of Your Honor at the PCC on March 14th, 2024. At that time, the defendant requested a PR bond. I objected to the PR bond, citing that Wayne County hold that was showing for her for an assault out of Wayne County. The defendant convinced Your Honor that Wayne County wasn't going to come get her. It sounds like that turned out to be accurate. However, the defendant was then released on a PR bond. Statutorily, she is not eligible for another PR bond.
Correct.
So while she's out on a PR bond, she walks up to somebody who, my reading of the police report, is perhaps a perfect stranger to her, and she steals keys from him while he's working. The police arrive, they're flagged down by this victim, and she proceeds to assault 3 police officers, leaving one with a laceration to his hand. When that deputy brought her to the jail, he had to receive treatment to the laceration to his hand in the jail. She had been out on a PR bond for not 2 weeks by the time she already began engaging in this behavior, which is one of the many reasons that I am not agreeing to any type of misdemeanor resolution in this case, and why I'm reviewing our request for a 25,000 cash surety bond in this case. Thank you.
Anything else?
Um,
Well, I just want to be clear. The plea was taken, so she was out on bond on the other matter. What about the matter, that matter went to Judge Valvo or to Judge Barr?
I believe,
I mean, I'm trying to figure out, was she on bond? Clearly, she was on bond on one of the cases. Was she on bond on 2 cases when this arose?
All I know is when I saw you a couple weeks, Your Honor. I don't know, I have to go in front of Judge Barr for probation on the 17th. I also have to go in front of.
So were you on probation at the time of
No,
this?
sir.
So when did you get on probation?
I was supposed to leave a report and I did. They weren't treating me with dignity and respect. So I had walked out.
Your Honor,
Yet,
she's scheduled for sentencing on both.
On which
I
one?
see Judge Bobo today for me not being able to report on time.
So on March 25th, She was actually on bond on 2 cases.
I believe so, yeah.
Motion for
Yes.
bond reduction denied, bond continued. All right, I've called the Payne matter.
Thank you, Judge. Good morning, Your Honor. Good morning to your staff. May it please this most honorable court, Edward Martell, P 85051, on behalf of Karen Payne. Ms. Payne, please state your full name for the record.
Karen Payne.
Have before me a plea form. Is that what we're doing today?
Yes, Judge.
All right. The plea form indicates that she will be pleading to operating while intoxicated, second offense, the 1-year offense. On her successful plea to that charge, the OWI third would be dismissed. That's the court's full understanding of the agreement.
That is correct, Judge. That is the defense understanding as well. Ms. Payne has been fully advised. She's prepared to be sworn and take the plea at this time.
Ms. Payne, can you raise your right hand to be sworn?
Yes,
Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole
Yes.
truth, and nothing but the truth, so help you God?
yes.
All right, you can put your hand down. State your name again for the record, please.
Karen Payne.
All right. Ms. Payne, it is this court's understanding that you are going to be pleading guilty to the charge of operating while intoxicated, second offense. That is a misdemeanor, punishable by up to 1 year in jail, 5 days to 1 year in jail. The court could also order community service and any rehabilitative programs the court deems necessary, and could order fines and cost up to $1,000. You understand that?
Yes,
The court could also order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
yes,
Understanding all of that, well, and understanding that you still wish to plead guilty to this offense?
yes,
I also do have to advise you that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Washington in the 14B District Court. You understand that?
yes,
All right. Still wish to plead guilty?
yes,
And to that charge, how do you plead?
guilty.
Now, you understand that by pleading guilty, you will not have a trial of any kind.
Yes,
Because of that, you're giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You understand that, man?
yes,
You understand you're giving up your right to appeal of right.
yes.
Are you on probation or parole?
No,
Has anybody promised you anything other than what's been stated here today on the record to get you to plead to this charge?
no,
Anybody threaten you or coerce you?
no,
You're doing this voluntarily
yes,
of your own free will
yes,
and because you believe that you're indeed guilty of this offense?
yes,
Was that a yes, ma'am? I'm sorry.
yes,
All right. August 27th, 2020, at the location of Textile Road, Ypsilanti Township, Washington County, State of Michigan, were you operating a motor vehicle?
yes,
Prior to operating that motor vehicle, you consumed intoxicating liquor.
yes,
Do you recall what you had and how much?
no,
Judge, we would
All right.
stipulate it to blood alcohol level.
What was the blood alcohol level?
Judge, I do apologize. I would defer to the prosecution. I don't have the report in front of me, but I do know it was in excess of 0.09.
0.304.
0.3, 0.304. Yeah, that's in excess. All
And
right.
Judge,
And
not
ma'am,
to-
all right, you got stopped by the police, is that correct?
yes,
All right. And you were ultimately arrested.
yes,
All right. And you were taken to the hospital for a blood draw. Is that correct, ma'am?
yes,
All right. And if I told you that the result of that blood draw were 0.304, would you have any reason to dispute those blood test results?
no,
Had you previously been convicted on or about November 19th, 2009 in the 34th District Court of operating while impaired or of operating while intoxicated on or about December 2nd, 2010, also in the 34th District Court?
yes,
All right. Counsel, have I complied with the court rule? Would it be proper to accept this defendant's plea?
People are satisfied, Your Honor.
Defense is satisfied, Judge.
Court will accept the defendant's plea of guilty to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14B probation. Sentencing in this matter will be
May 16th at 10 a.m. before Judge Washington.
May 16, 2024, 10 a.m.
Yes.
10 a.m. before Judge Washington.
thank
Bond
you,
with its conditions will continue. Thank you.
thank you.
Thank you, Judge. Always a pleasure. Have a great day.
Thank you. Calls the case of the people versus Chelsea Miller.
Alex Warren, agreeing on behalf of Ms. Miller.
Ms. Miller?
Can you hear me?
Yes, we can hear you. Do you have a camera?
Yep, I'm trying to turn it on. There we go.
Okay, state
work?
your name, please. Yes,
Chelsea
we can
Miller.
see you. Can your name again?
Chelsea Miller.
To the plea we're doing?
That's right, Your Honor.
Court has before it a plea form that indicates that the defendant will be pleading guilty to added count 3 and 4. Count 3 being use of a controlled substance, that being fentanyl, 1-year offense, and count 4 being operating while visibly impaired, the 93-day offense. Upon her successful plea to those charges, counts 1 and 2 would be dismissed. There is an agreement that it's okay to seek 7411 on the added count 3, although I cannot bind the court to do that. But that's the court's full understanding of the agreement. Is that correct, counsel?
Yes, Your Honor.
Hughes wasn't even stepping in. She just looked. Yeah. She just looked at him like, say something. All right. Ma'am, could you please raise your right hand? Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record, please.
Chelsea Miller.
All right, you can put your hand down. And it is this court's understanding that you're going to plead to 2 misdemeanor charges. The first charge is that of the use of a controlled substance, that being fentanyl. That's a misdemeanor punishable by up to 1 year incarceration and or a $2,000 fine plus court costs. You understand that?
Yes.
Also, this court's understanding you're going to plead guilty to the charge of operating while visibly impaired. That's a misdemeanor punishable by up to 93 days in jail, up to a $300 fine plus court costs. The court could order community service or any rehabilitative programs the court deems necessary. The court could order your vehicle immobilized, could order you to pay the cost of the prosecution as well as the cost of any emergency governmental services. You understand that?
Yes.
All right. You also understand, ma'am, that while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Freshour in the 14A3 district. You understand that?
Yes.
Okay. Understanding all of that, do you still wish to plead guilty to these charges?
Yes, Your Honor.
To the charge of use of a controlled substance, how do you plead?
Guilty.
To the charge of operating while visibly impaired, how do you plead?
Guilty.
Now, you understand that by pleading guilty, you'll not have a trial of any kind.
Yes.
And you understand because of that, you're also giving up certain rights. You're giving up your right to call witnesses to speak for you at trial or to have this court compel their attendance. You're giving up your right to see, hear, and question all witnesses against you at trial. You're also giving up your right to be a witness for yourself or to remain silent, not have that silence used against you. And you're giving up your right to be presumed innocent until proven guilty beyond a reasonable doubt. You
Yes.
understand you're giving up those rights, ma'am?
Yes, Your Honor.
You understand you're giving up your right to appeal of rights?
Yes, Your Honor.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead guilty?
No, Your Honor.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
And also because you believe that you're guilty of these offenses?
Yes.
September 3rd, 2023, location of I-94 near Zebra Road, Scioto Township, Washington County, State of Michigan. Were you operating a motor vehicle?
Yes.
Prior to operating that motor vehicle, had you ingested a controlled substance?
Yes.
What had you ingested?
I had marijuana and Flexerol. I believe they were oxys, fentanyl.
Pardon?
I believe they were oxys, but I found out that later that they were fentanyl.
Okay. All right. Were you stopped by the police?
Yes.
Okay. Why'd they stop you?
I guess somebody had called and said that I was driving erratically.
All right. You're not challenging the right of the police to stop you in this instance, are you?
No.
All right. Were you ultimately arrested?
Yes.
And were you taken to the hospital for a blood draw?
Yes.
And did a combination of controlled substances appear on that blood draw, including marijuana,
Yes.
as well as the fentanyl?
Yes.
Do you have any reason to dispute those test results?
No.
All right. Taking everything into consideration on that date and at that time, do you believe that your ability to operate that motor vehicle was visibly impaired due to your ingestion of controlled substances?
Yes.
All right. I'm having a problem only, ma'am. When you took what you thought was Oxycontin, you believe that that's what it was. Is that correct?
Yes.
Okay. So you did not know that you were ingesting fentanyl?
No.
She was not prescribed Oxycontin, Your Honor.
Right. So you want to do it to the Oxycontin. Okay. So you at least knew or thought what you were taking or intentionally thought that you would be taking Oxycontin.
Yes.
All right. It turned out to be something else, but you thought you were going to take a controlled substance that you were not prescribed. Is that correct?
Yes.
All right, I think that will do it. Counsel, have I complied with the court rule? Would it be proper to take this defendant's plea to counts 3 and 4?
And the defense is satisfied.
Court will accept the defendant's pleas of guilty to counts 3 and 4. Counts 1 and 2 are dismissed. Pre-sentence investigation and report is ordered. Sentencing in this matter will be May 6, 2024, 9 a.m. 9 a.m. before Judge Freshour.
Okay, thank you, Your Honor.
Bond with its conditions will continue. Thank you, ma'am. Court calls the case. People versus, is it Ruhala Hatame? Probably messed that completely up, but I tried.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Mr. Hamte.
I have before me a plea form that indicates the defendant will be pleading no contest to the charge of indecent exposure to 1-year offense. Upon a successful plea to that charge, the aggravated indecent exposure would be dismissed. That's the court's full understanding of the agreement.
Ours as well, Your Honor.
Raise your right hand. You solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God.
Yes.
State your name for the record.
Ruhola Hamtai.
All right. Sir, it is this court's understanding that you are going to be pleading guilty or pleading no contest to the charge of indecent exposure. That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. Do you understand that?
Yes, Your Honor.
Do you understand what a no contest plea is?
Yes, Your Honor.
All right. 2 things about it. I need to make sure that you understand it. First of all, means that you're not desirous or wanting to contest this charge. You understand that?
Yes, Your Honor.
Second thing you need to understand is that for purposes of sentencing, the court would treat you the same as though you had pled guilty. You understand that?
Yes, Your Honor.
You understand that while I'm taking your plea, I would not be your sentencing judge and you would be sentenced before Judge Freshour in the 14A3 District Court.
Yes, Your Honor.
All right. Still wish to, and basis for the no contest plea.
Civil liability, Your Honor.
To the charge, how do you plead, sir?
No contest, Your Honor.
You understand that by pleading no contest, you'll not have a trial of any kind.
Yes, Your Honor.
You signed an advice of rights form today.
Yes, Your Honor.
Any question about those rights?
No, Your Honor.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on their form.
Yes, Your Honor.
You understand you're giving up your right to appeal of right.
Yes, Your Honor.
Are you on probation or parole?
No, Your Honor.
Has anybody promised you anything other than what's been stated here today on the record to get you to plead no contest?
No, Your Honor.
Anybody threaten you or coerce you?
No, Your Honor.
You're doing this voluntarily
Yes, Your Honor.
and of your own free will.
Yes, Your Honor.
Court has been provided and is reviewing Washington County Sheriff's Office report for their case number 23-40842. Any objection to the court reviewing that report?
No, Your Honor.
Based upon a review of that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2. Count 1 is dismissed. Pre-sentence investigation and report is ordered at 14A3 probation. Sentencing in this matter will be
May 6 at 9 a.m. before Judge Freshour.
May 6, 2024, 9 a.m. before Judge Freshour. Bond in this matter with its conditions will continue.
Slight request, Your Honor, about bond.
Really?
I know.
Somebody's gonna do that and they're gonna go. Go
Two
ahead.
sentences, Your Honor. Mr. Hebtai is hoping to travel on Monday to Ohio and or Indiana to see the eclipse. It's something he's looked forward to for a very long time,
Ohio or Indiana?
depending on weather conditions. Preferably
Because
Indiana.
you can't see it here?
You can see it here, Your Honor, but it won't be in totality. So all it takes is to travel to Toledo. And I highly recommend, Your Honor.
Yeah. No, for us Michiganders, that's disputed territory. We don't go there on purpose.
Please, Judge.
Please. Fine. But you don't know whether you'll be in Ohio or Indiana.
Most likely Ohio, but if the weather is not cooperating, Indiana.
That's definite. Defendant may travel to Ohio or Indiana for eclipse.
Thank you, Your Honor.
Court calls the case People versus Rebecca Usselman.
Andrew Danis, Assistant Public Defender, with on behalf.
Your name?
Usselman Rebecca.
You made it all the way from Royal Oak, but the other one couldn't make it from Hanover. Go ahead.
Your Honor, we have resolved this today. The offer. I saw it on your face. Your Honor.
Yeah.
Police report.
My face, everything. When we do this, if we could, Venice, get it to my staff as soon as possible.
Yes.
I would appreciate it, because then I have a chance to review it more closely, but we'll make it work. All right. I have before me a plea form that indicates that the defendant will be pleading no contest to an added count 3 of attempted resisting and obstructing the 1-year offense. That upon a successful no contest plea to that charge, counts 1 and 2 would be dismissed, agreement of no delayed or deferred. That's the court's full understanding of the agreement.
That is correct.
Raise your right hand. Do you solemnly swear or affirm testimony you're about to give will be the truth, the whole truth, and nothing but the truth, so help you God?
Yes.
State your name again for the record.
Becca Usselman?
All right. Ma'am, it is this court's understanding that you're going to plead no contest to the charge of attempted resisting and obstructing a police officer.
Yes.
That is a misdemeanor punishable by up to 1 year incarceration and or a $1,000 fine plus court costs. You understand that?
Yes.
Do you understand what a no contest plea is?
Yes.
Okay, 2 things I have to make sure you understand about a no contest plea. The first being that it means that you're not further desirous or wanting to contest this charge. You understand that?
Yes.
Second thing is that for purposes of sentencing, the court will treat you the same as though you had pled guilty. You understand that?
Yes.
I also do have to advise you that I would not, while I'm taking your plea, I would not be your sentencing judge, and you would be sentenced before Judge Valvo in the 15th District Court. You understand that?
Understood.
Basis for the no contest plea?
Potential civil liability.
Ma'am, to that charge, how do you plead?
Say it again?
How do you plead to the charge of attempted resisting and obstructing?
No contest.
Now, you understand that by pleading no contest, you'll not have a trial of any kind.
Yes.
You signed an advice of rights form today, is that correct?
Yes.
Any questions regarding any of those rights?
No.
Please look at paragraph 5. You'll see a copy on the podium. Those are your rights which are part of a trial. You understand by pleading no contest, you're giving up those rights as well as all the rights on that form.
Understood.
You understand you're giving up your right to appeal of right.
Understood.
Are you on probation or parole?
No.
Has anybody promised you anything other than what's been stated here today on the record?
No.
Anybody threaten you or coerce you?
No.
You're doing this voluntarily and of your own free will?
Yes.
Court has been provided and is reviewing Ann Arbor Police Department report for their case number 245900. Any objection to the court reviewing that report? Reviewing that report, the court does find that there's a sufficient factual basis in which the court could determine the defendant's guilt of this offense. Counsel, have I complied with the court rule?
Yes, Your Honor.
Court will accept the defendant's plea of no contest to count 2 or count 3. Counts 1 and 2 are dismissed. Pre-sentence investigation and is ordered at 15th District Court probation. Sentencing in this matter will be
30 before Judge Valvo.
April 17th.
Yes.
April 17th, 2024. What time?
30.
2, of course. Why? 2:30 before Judge Valvo. Bond will continue. Thank you. He can have that back. Court calls the case People versus Marcus Williams.
First Assistant Public Defender Quinn Anderson was on behalf of Mr. Williams. Mr. Williams, state your name, please.
Marcus Williams. Thank you.
Your Honor, we're going to set this for a preliminary exam, and at the appropriate time, I'd ask to address his bond. Put that away.
But he's out.
And we want to keep it that way.
Yeah, okay. You have all discovery?
Yes, Your Honor, thank you.
Would the witnesses be available the 16th? Preliminary examination in person will be set April 16th, 2024, 9 a.m. before Judge Fresh Hour. Yes, Ms. Anderson as to bond.
You ready?
Sure. Hey, I'm good. I'm ready to roll, always.
Your Honor, he's currently on a hot zone tether. He presents to the court with no prior convictions on his record. This is financial hardship, obviously, but I've not received anything indicating that he has violated the tether conditions or any of his bond conditions since the arraignment. He's asking the court to consider removing him from the tether and just keeping the no contact, no go to in place.
I don't need a response. I'm not going to do that. I've got 2. I understand the presumption of innocence, but I have 2 DV charges on this, and his tether is an exclusion. So there's the only other way that I could assure his exclusion from that area would be to incarcerate him, and I don't think you want that alternative.
No, thank you, Your Honor.
All right. Bond will continue.
All right, thank you.
You're welcome. Court calls the cases of the People versus Beverly Tuttle.
Mr. Ganatra, Senior Assistant Prosecutor.
On behalf of Ms. Tuttle. Your Honor, Ms. Tuttle called our office earlier today and informed us that she was not able to secure transportation for her hearings today. And she also advised us that she's looking obtain a private attorney.
She couldn't obtain transportation.
Well, and maybe if she's saving for the private attorney, she's not able to Uber.
She couldn't obtain transportation from Ann Arbor.
That's my information. That is my information.
From Ann Arbor.
The Uber fees are going.
Bus stop right out there. Is that all you got?
That's my
That's it,
information.
okay. Bench warrant. Bond. Bench warrant will issue both of these matters. Bond set at 10,000 cash as surety. Those warrants will issue immediately. Thank you. Calls case People versus Cortez Weston Hinton.
First Assistant Public Defender Clooney Anderson with on behalf of Mr. Weston Hinton, please state your name.
Cortez Weston Hinton. How are you?
Your Honor, this will be a waiver. We're going to seek HIDA in the circuit court.
Sir, is that correct that you're waiving your right to a preliminary examination?
Yes, sir.
All right, you understand that preliminary examination is a proceeding where the people would have to show by probable cause that the offense alleged was committed and that you committed it.
Yes, sir.
You understand you'll not have that hearing. You'll proceed to circuit court for further resolution.
Yes, sir.
People also waive their right. Preliminary examination having been waived, defendant's bound over on a single count. Ms. Sanders.
Thank you, Your Honor. We received a copy of the information. Waive its formal reading, stand mute.
Defendant having waived formal reading, standing mute. Court will enter not guilty plea. Pretrial will be set for
May 13th at 1:30 before Judge Slay Monday.
May 13th, 2024, 1:30, Slay Monday.
What you got in your hand? That's something for me?
Bond in this matter will continue. Thank you, sir.
Your Honor, he does have his completed fingerprint order. Should he just take that to the front counter?
Court calls the case of People versus Raymond Tubbs.
Ready to commercial police assistant public defender on behalf of Mr. Raymond Tubbs. State your name for the record.
Raymond. Inside or off, either way. All right, thank you. Mr. Feaster knows with a bald head, it's easier to slide over. Go ahead. No, it's okay. You're all right.
I've spoken to Mr. Tubbs and to Mr. Ganache on this file. We're working on getting it resolved. Not quite there yet. If we could have a week or two, please.
Probable cause conference, April 25th, 2024, 9 a.m. Bond continued.
You got my number. I'll give you the. Thank you very much.
Thank you. Court calls the case of the People versus Alan Norris.
On behalf of the people.
Good afternoon, Your Honor. Dave Coleman, appearing for today's hearing only on behalf of Mr. Haney, who could not be here today. Mr. Morris is here.
Okay, and you have no objection to?
I have no objection.
All right, very good. All right, what are we doing?
I was emailing back and forth with Mr. Haney. Ms. Barroso had been handling this case, although she had made me aware of some things going on. We're looking to adjourn this just one last time in hopes that it can be resolved.
All right, how much time do we need?
I don't know Mr. Haney's schedule, but
I don't either. No.
perhaps.
Why don't we do, shall I do the 25th and then see?
That would be fine.
All right, probable cause conference, April 25th, 2024, 9 a.m. Bond continued. Thank you, sir.
Thank you, Judge.
Thank you. Court calls the case People versus Dennis Thick.
Andrew Bannis, Assistant Public Defender with on behalf of Mr. Dick.
Good morning, Your Honor. Dennis Thick.
Thank you. What are we doing?
I'm asking for an adjournment. We are very close, I think, to resolving this case.
Probable cause conference, April 18th, 2024, 9 a.m. Bond continued.
April 18th, come back.
Yeah, yes, sir. Thank you.
Thank you. Judge.
Court calls case People versus Kenya Weatherspoon. Thank you.
Attorney Feaster, Assistant Public Defender, Mr. Weatherspoon. And for the record.
Kenya Witherspoon.
Thank you.
Thank you, Judge. This is my first time meeting Ms. Weatherspoon. I believe our first pretrial on this file. My understanding is we need to have some serious conversation. This is a serious case, so we're gonna take some time to try and get this figured out. If we could go out 3 or 4 weeks, please, Judge.
Without objection, April 25th, 2024, 9 a.m. Bond continued.
Thank you, Judge.
Court calls the case People versus Lori Williams.
Joy Gaines, Senior Assistant Public Defender representing Ms. Williams. Your Honor, Ms. Williams is working with our mitigation team, and we are asking for some additional time, maybe 3 weeks. So
To
that
do
they,
the letter, 3 weeks to do a letter. Without objection, probable cause conference, May 2nd, 2024, 9 a.m. Bond continued.
thank you.
Court calls the case People versus Jada Olive.
Good afternoon, Your Honor. Sam Bernstein with and on behalf of Ms. Olive, who is present.
Yeah, but Mr. Cash is withdrawn.
He's here.
I know, I saw him running around, but he's not here right now. What are we doing? You're going to be requesting an adjournment. And
Correct, Your Honor.
let him withdraw. I'll grant his motion. Probable cause conference will be adjourned 25th,
Thank you, Your Honor.
2024, 9 a.m. All right. Bond continue.
Good rest of the day, Your Honor.
Thank you.